Okay, I think we can go ahead and get started. Number one, thank you everyone for your patience today. We were just dealing with a few technical issues, but we are so glad to get started. Hello and welcome. My name is Tracy Slater-Rago. I'm the Senior Director of Philanthropic Practice and Partnerships at the Forum. And we're so pleased that you're able to join us for our first of several Ask a Nonprofit Lawyer sessions. Today's conversation is an opportunity to ask questions you may not always have the opportunity to ask about nonprofit legal issues. And so we're grateful that you're here and encourage you to use this time to consider what's most pressing for you and your teams right now. Before we open the floor, it's my pleasure to introduce to you Jeff Tannenbaum, founder of the Tannenbaum Law Group and a nationally recognized nonprofit attorney with decades of experience in advising foundations, associations, as well as mission-driven organizations like many of our members. Jeff works at the intersection of law, governance, and public purpose, and has helped countless organizations navigate moments of complexity and change with clarity and confidence. And so we're so delighted to have you here with us today, Jeff. Now we are going to open the floor to you, our members, and we encourage you to share the legal questions that you are currently grappling with.
Thanks, Tracy. Before we get into that, let me just maybe set the stage a little bit. Just so you know a little bit more about my background and my perspective here, I am managing partner of Tannenbaum Law Group. We're a 6-attorney boutique firm based in Washington, D.C. All of our clients are nonprofit organizations all across the country, primarily national and international nonprofits of all different types, shapes, sizes, every type of nonprofit imaginable. And for most of our clients, we serve as kind of outside general counsel dealing with a broad array of all of their different legal issues. I've spent my entire 30-year legal career in private practice in DC, exclusively representing nonprofit organizations. For 20 years, chaired the nonprofit practice at a large law firm called Venable, and then started this firm 6 years ago with my law partner, Nisha. Just about every legal issue imaginable we deal with day in and day out for hundreds of different nonprofit organizations. So we have a very kind of good vantage point into the legal risks and challenges and threats facing the nonprofit sector. We counsel hundreds of clients every month on various issues. And so I'm here to share that perspective with you today. For some of the questions that you might ask, I might kind of set the stage with 5 minutes of kind of background or context on that area of law to make sure that you have that perspective before I dive into answering your specific question. Some of it might be questions that you have. Some of it might be just an area of law that you're interested in learning a little bit more about that you don't have a great understanding of. Obviously, with the time and the format, I can't get into too much detail on any one topic, but certainly try to give you enough to be able to have a decent understanding of the core issues and for that particular legal issue. Feel free to ask anything you want. Just unmute yourself at the small group, ask your questions. Feel free to ask follow-up questions. If others of you have, after I give some response, if you have other commentary or war stories or examples of how you've dealt with similar issues or challenges, feel free to chime in with that as well. And I'd encourage the staff to do the same in terms of asking any questions that they want to hear about. So who wants to get us started here today? Give me a question or topic you want to learn more about.
Let's start us off if that's okay. My name is Emily Anderson. I'm with Philanthropy, Ohio. Thank you to the forum for putting this on. I had it on my calendar and I was like, great, because I have a question. I'm currently sitting in our office, which we are going to be moving out from, but we have lots of files that are very old. And, it's been a while since we've had someone in the seat who kind of holds the retention policy, and we haven't looked at that in a long time. So I know, like, generally retention policies and the years you need to keep things, but my big question around it is if it actually has to be the physical copy of, say, a bank deposit slip or the board minutes, or really, like, having it in our cloud as a scanned document suffices.
Yeah, it's a great question, and it's important. It's an important one. It's kind of one of the more mundane issues that we deal with, but it is a very important one. And it's important for several reasons. Before I answer your specific question, which I will, let me kind of give you a little background and context. So, for some types of records, there are legal requirements, whether they come from federal, state, or local law or regulation, that you have to keep certain things, certain documentation for certain periods of time. In other cases, some records can become a liability for your organization, whether it's employment-related liability or pick your potential form of liability. Sometimes having records and keeping them too long is not advisable because you are adding to your potential liability risk, whether it's direct liability for your organization or nonprofits are frequently targets of what we call third-party subpoenas, meaning you're not a party to litigation, but you get a subpoena because you have some information or documentation that's relevant to it. And sometimes it just can make it less burdensome on your organization if you don't have certain records. But the bottom line is you always want to be sure, like you referenced, Emily, to have a solid record. Some people call it a record retention policy. Some people call it a records and information management policy, and some call it a document destruction or retention and destruction policy. Whatever you label it, it's important to have a policy and to follow it. And the latter part is what doesn't happen in a lot of nonprofit organizations, especially smaller ones that don't have as many staff. It can just become burdensome, but it is really important to do so because you never want to be just willy-nilly destroying records, which later could, in some instances, come back to haunt you. But if you're doing it pursuant to an established, record management policy, and you're deleting, for instance, emails, after a certain period of time, or other sorts of records, you're going to be much better protected in that regard. And you're going to make sure that you're holding on to things for legally required periods that you need to. And sometimes it's also about defending yourself. Like, say you get a claim from a terminated employee a year later that claims that she was improperly classified as an exempt employee when she should have been non-exempt, and therefore she's eligible for all these hours of overtime that she worked. Well, if you have good records establishing when she did work, in fact, that's going to be critically important to your defense. And those sorts of employment-related claims in most states and federally are going to have typically a 3-year statute of limitations, meaning you can bring the claim anytime within a 3-year period. And so some cases you're going to want to make sure you have those time records to be able to show, no, in fact, you were not improperly classified. And B, even if you were, you weren't working more than 40 hours a week, so you're not entitled to any overtime. Of course, in that situation, they still might be entitled to things like employee benefits and retirement plan contributions and the employer share of the payroll taxes and other stuff that you would have to pay. I'm conflating two issues. I'm conflating the employee versus independent contractor issue. And that's another potential misclassification where you're going to want to have good records that someone was an independent contractor, but they claim they should have been classified as an employee. And so in both of those situations, with the exempt, non-exempt, it's really about overtime. For the employee versus independent contractor misclassification issue, it's about all of the things that the employer would pay for an employee that they don't pay for a contractor, which can be significant. But again, in both cases, you want to make sure you have good, proper records to defend yourself, but that you're not holding on to them for too long. So we actually have a model kind of starting point record retention policy for nonprofits that, Tracy, I will send to you to share with everyone after this webinar if you want. And that'll be helpful. You always need to be sure that it's tailored to your particular organization and your particular state. But, even if you did nothing more but use it as a template, it's going to serve you fairly well, because it has, pretty standardized average, type retention periods for most of these documents. In terms of your question about paper records, I've been doing this for 30 years ago, most records were still kept in paper form. It was just starting to be a lot more electronic storage. And a lot of the laws hadn't caught up with, allowing things to be stored electronically. That, if there was like a mandatory retention period, a lot of the laws used to refer to, or at least imply, that it was paper documents that had to be retained. That is no longer the case. That is absolutely no longer the case. Nothing has to be stored in paper form. Everything can be digital. Everything can be scanned in, stored in the cloud, which I will just say sometimes that creates a temptation or a disincentive to engage in your regular document destruction because it's just so easy to store. Storage is so inexpensive these days that it's just easy just to leave it all there. But again, for some of those reasons I described earlier, particularly for liability concerns and third-party subpoenas and other things like that, you don't want to keep things generally any longer than the retention periods would provide for. Does that answer your question?
Yes, and that makes me very happy because I don't want to move all of these binders and cabinets full that definitely need to go through the policy. So thank you so much for
Yeah,
that.
and it sounds like you have a policy already, it should be a board approved policy. And if you do, then you can apply it now and, just
Mhm.
obviously be sure to shred things that have any sensitive or confidential information, for sure. But that should make your life a lot easier. And are you going to like a purely virtual environment?
Probably not. So we're still kind of working through that. We're waiting actually for the RFPs to come back this week for just a potential different office that would be smaller. So that would be the change. It would be actually, Deborah knows, downstairs from where I'm currently sitting. So it's kind of funny, but so yeah, most likely not. But if we can't get a release that is within our budget, then we would go virtual until we figure it out.
Okay, it just raises another issue that we get from a question, an issue that we deal with from actually quite regularly from clients, because so many nonprofits have gone to a fully virtual environment, which is fine, completely fine and appropriate. A couple legal issues to point out, though. There are a variety of reasons why you still need to have some physical address, not a physical location, but a physical address as your kind of headquarters address. There's a lot of different, some are IRS based, some are others, some are state based, where they require you to not just have like a PO box, but to have some sort of a physical mailing address. And there are plenty of companies out there that do this now. Like Regis is a big one, REGUS, that does it. A lot of nonprofits use them, but there are plenty of others as well. And some, like I believe Regis, or at least some other locations have, like they'll receive mail for you and they'll like scan it in and email it to you and things like that. Which is, even though so many things don't come by mail, some things still do, including, by the way, the IRS. IRS only deals with mail and fax, believe it or not. They don't deal with email. And so, if you get a notice that you didn't file your Form 990 timely or something like that, it's going to come in the mail. And so you want to make sure you have some ability to receive that. So, make sure that you still maintain, obviously you're in Ohio, so it would be some sort of a mailing address, even if you're not physically located there in Ohio. Also, another thing that a lot of people don't realize that, presumably all of your organizations are federally tax exempt, 501c3, presumably tax exempt organizations. And to maintain that exemption is, you have to file the Form 990, whatever form, the regular 990, the 990EZ, or the 990N, depending on your size, with the IRS each year. And if you fail to do that 3 years in a row, you automatically lose your exempt status. But what a lot of organizations don't realize is that you are also supposed to seek state corporate income tax exemption from whatever state you are headquartered in. And for those of you that are national organizations, and maybe only UPF is the only national organization, it's not your state of incorporation. It's a state where you're deemed to be headquartered. And that's where you're supposed to, assuming the state has a corporate income tax, and not every state does, but if the state has a corporate income tax, then you need to apply for state corporate income tax exemption. Now, if you have an IRS determination letter, it's generally a very simple, easy process. It's almost automatic, but you do need to apply for it. And then most states require you to file a copy of the Form 990 with that state tax office every year. If you have an annual audit from outside auditors, they're generally pretty good about staying on top of those requirements, but it's surprising to me how many organizations don't do that. And then the last thing I want to say when it comes to remote workforces and physical addresses and whatnot is that I referred to your state of incorporation a minute or two ago, and that's very important because that is the state nonprofit corporation law that is going to govern your organization, regardless of where you're located. So we have hundreds of clients, nonprofit clients. Many of them are incorporated in one state, but they're headquartered in another because some founders, 70 years ago founded the organization in Illinois, but now, they're based in Washington, D.C. or New York or Ohio, we'll pick your place, which is fine, absolutely fine to be incorporated in one state, headquartered in another. But what that means is a couple things. One, always be cognizant of your state nonprofit corporation statute because that's what's going to govern things like your bylaws and other governance related matters. Also, major transactions like mergers and dissolutions and substantial transfers of assets. Those are all going to be governed by the state nonprofit corporation law of your state of incorporation, not where you're located. If you're located in a different state, you are supposed to what's called qualify to do business as a foreign corporation in that state. And that, again, it's a pretty simple, easy process to get qualified to do business as a foreign corporation. But you also have to maintain a registered agent there and file the annual report with the state. Most states require that. And then if you have remote employees in other states, which a lot of nonprofits do, we have some clients that have remote employees in 40 or more states. What does that mean for your organization? Well, it means two things in particular from a legal perspective. One is that you are supposed to qualify to do business as a foreign corporation in each of those states where you have an employee, because it's the functional equivalent of having an office there. So you are doing business in that state, and you're supposed to qualify to do business, which again, pretty simple filing, but then maintain a registered agent. And there's companies that will serve as your registered agent, for like $150 a year, and then file that annual report with the state. But the other thing that it means is that from an employment law perspective, each employee is going to be governed by the state in which they are principally working from. And not every state's employment laws are the same. And of course, we have federal employment laws. Not all of them are going to apply. Probably a lot of them won't apply to your organizations because they're too small, because they're based on how many employees that you have. But most state employment laws apply to as few as one employee. Not all, but most do. And they vary from state to state. Like, for instance, in California, which has very different employment laws from the rest of the states, overtime for non-exempt employees is calculated on a daily basis, not a weekly basis. So if you work more than 8 hours in a day as a non-exempt employee located in California, you have to get paid overtime at time and a half per day. So even if you're working at a conference and you're working, 10, 12-hour days, and then your employer says, take the rest of the week off so that you don't work over 40 for total in the week. That would work from a federal level, but it doesn't work from a state level in California. Also in California, it's very difficult to be classified as an independent contractor. There's a law that gives a very strong preference toward being an employee with some very limited exceptions. And also in California, if any of you, are incorporated in California, I don't know if any of this group is, but the California's employment laws apply to nonprofit volunteers as well as employees. It's the only state I'm aware of where nonprofit volunteers are treated like employees. So all of the anti-discrimination, anti-harassment laws actually apply to volunteers in California. So that would pretty much mean if you're either a California nonprofit corporation or you're headquartered there. But anyway, just be very cognizant of that, because it can make things, even like your employee handbooks and other things, a little more cumbersome, because you have to make sure you're tailoring it to employees in each particular state. I saw there were some questions in the chat that popped up in response to some of what I was saying. If you guys just want to field those or ask them to me directly, whatever your preference is.
Great. Thanks for that, Jeff. Laura, I see you came on camera. Do you want to share your follow-up question?
Yeah, thank you, Tracy, and thanks, Jeff. And we're the League of California Community Foundations, so we're in that whole soup of extra regulations around HR. It's one of the reasons we only have two staff. It's just such a slog to navigate. But that's actually not my question. I had a follow up on the mailing addresses, so thank you to whoever brought that up. We're a remote organization with just the two of us. We've never found it worthwhile to have a physical office, and we couldn't really pick a place in California if we did so. So we've been using PO boxes where my colleague lives. She's been moving around. We have a WeWork office that we're letting go of soon, and we've kind of like pinged our address situation around and are looking for a more durable solution that also gets around or addresses the fact that you can't use a PO box for everything, as you say. So I just wonder if you could restate the group you said that folks use, and if it matters that for us as a statewide association, we are headquartered in California, only operate in California. Does it matter that we use someone that's in California?
Yeah, your address is going to need to be a California address,
Yeah,
but
right.
the company, and I'm not endorsing it. I don't even really know much about them. I just know I've heard the name pop up quite a number of times from clients. It's called Regus, Regus. They're
Regis.
definitely one of the bigger ones, nationwide companies that performs this kind of service.
Yeah.
But I know there are others, and others might be more cost effective. I have no idea, but
Okay,
it
thank
shouldn't
you.
be hard to do a Chat GPT or a Google search and find some companies that perform that service.
Great. And then I have a follow-up question, Tracy, if that's okay, unless someone else wanted to tag
Sure,
on
go
to
ahead.
the other things. So we, like I think a lot of associations, we collect data from our members and we publish reports. Sometimes it's a one-off, like someone will have a question, hey, how's everyone handling XYZ? And we provide that information back to members, but we also administer two of our own annual surveys. One on, we call it the profile, really on like high level assets, grant making, gifts, et cetera. And then one on compensation and benefits that we structure similar to how the council does it. And I think the forum by like different metrics, asset level, asset size, et cetera. And we've been advised that we should, as we look to sort of expand those, we have more members, we keep getting requests for collecting and disseminating more and more kinds of data. I wondered if you could give us any advice on how to approach antitrust issues around the kinds of information that we're collecting and sharing. Is there like a central source that we should be looking at for guidance on that? Is that something that is state specific, is my other question.
No, that's not going to be state specific. To answer your last part of that question, it's going to be pretty much driven by federal law. California has its own antitrust statutes, like every state does, but they generally just track federal law in this regard, which is largely, it's set by the courts, interpreted by the courts, because the federal antitrust statutes themselves are pretty sparse, and most of the law in this area certainly comes from like federal agency enforcement as well as court-made law, including tons of Supreme Court decisions. But to answer your question, so I just gave an antitrust presentation out in your state last week in San Diego or Del Mar for a group of the largest electrical contractors in the country. And this was one of the things that we were talking about that they asked me about was, what I'll put in the bucket of kind of information exchanges, all sorts of, and it's a very common role for associations to play to gather, information, data from its members, and then publish it either to its members and or more broadly publicly. And for some very large national associations, this is really important economic data that a lot of folks rely on as well. But because of the prohibition on what's called price fixing in Section 1 of the Federal Sherman Act, which makes it illegal for two or more competitors to agree to do certain anti-competitive things, the most serious one being agreeing on prices or fees to be charged. Because salaries and compensation are such an important factor in prices and fees that are charged. And look, you might not think of, you're an association of community foundations, right? You might not, I guess one might argue if the community foundations themselves are not competitors, then you could argue that the antitrust laws don't apply. And that might be the case. But if they are competing, whether it's for, DAF participants, donor advised funds, or whether it's for, grant funds from private foundations, or whether it's other things that they are competing for, then they could be deemed competitors, in which case the antitrust laws would apply. Certainly not in the way like the group I spoke to last week, the National Electrical Contractors Association. That's clearly, a classic group of competitors in a particular industry. You're a little bit different. But if there's even the remote chance or some chance that your members would be deemed competitors, then the prohibition on price fixing is going to apply. In which case, it doesn't mean you can't gather that information. But what you want to do is follow this. It's not technically a safe harbor anymore. But for now, unless and until it's replaced with some other guidance, it's still, in my view, and a lot of others, still a best practice to follow and the safest way to do this. So for probably 2.5 decades, the U.S. Department of Justice Antitrust Division and the Federal Trade Commission jointly put out this safe harbor for basically how to do these sort of information exchanges and data gathering. And they had kind of several different steps in the safe harbor. And I still advise clients to follow it. One is that, and it's for any time you're collecting like competitively sensitive data, which would certainly include compensation. The first is that the data should be at least 3 months old at the time that it's collected. Now, again, this is just a safe harbor. It doesn't mean you're going to violate the law if you don't do this. And there are some, even of our clients, that collect current data. They don't collect 3-month-old data because that's what the market wants. And, it all depends on your risk tolerance and whatnot. But, the former safe harbor said the data collected should be at least 3 months old at the time it was collected. Certainly not future forward-looking data. Like you do not want to be collecting data on, and I cringe every time I see like on an association listserv or Collaborate forum, something like, oh, what are you guys going to be doing next year for salary increases? What percent are you going to do?
Or how are you adjusting your
ill-advised to ever talk about future data, because that's when you get into really serious price fixing risk. So that's one thing. Second thing is the data should all be aggregated so that, it's basically just all an average or otherwise aggregated so you can't identify any individual participants. There should be at least 5 participants in each category, and no one participant's data should constitute more than 25% of the total in that category. And then finally, the data collected should not be at all collected by or exposed to the members of your association. It should be done either by staff or by like some larger associations use outside consulting firms to do. Either is fine, but the members themselves should not be collecting the data or have access to the raw data. And so, that's still kind of the good guidance to follow for engaging in that sort of activity.
That's great. Thank you so much. And can I just clarify the second to last thing you said was any one participant in the data shouldn't constitute more than 25% of that category?
For that category, yeah.
For that category.
And I have an article on this that I will send you.
Yeah, great. Thank you.
Well, I'll send it, Tracy, to send out to you guys. And it has all of this in there. Again, I haven't updated the article since the DOJ and FTC formally withdrew that safe harbor about a year ago, but it's still good guidance to follow.
Thank you.
Thank you for that question and your follow-up, Laura. We also have a question from Michelle. Michelle, I know you have a couple of questions, but once you're done with your questions, Jeff, just a heads up that we do have a question from Tony Shields that he submitted via the website. And so we'll get to that after we hear from Michelle.
Sure.
I can start with one. And the second one, I know you've talked to us about before, Jeff, so I might need to just look at my notes. But the first one is that our members have asked for a way, like a virtual platform to share, let me read it correctly. So to share vetted nonprofit project proposals. So they've looked at them that they cannot fully fund with other funders. And we're wondering about legal considerations, like an Airtable type setup where they're sharing information. One of the things
explain to me, Michelle, I'm not really grasping what we're talking about.
So we have some really big foundations and some small ones. Really big ones are getting hundreds of applications, many of which are great, strong applications that they would fund if they had unlimited resources, but they don't. And then we have smaller foundations that just don't have the same volume coming in that would be interested in funding something and interested in the help vetting it. And so we're looking for a way to share that application so that another funder in the state could say, actually, I could contribute to that project and help fill it. So it's not a pooled fund. It's not a guarantee. It's just a peer-to-peer, hey, I heard about this cool project in this community. You fund in this community. Would you like to fund it? That's how they've been doing it now. They have to know the other funder and do it. And then we'd like a sort of a spreadsheet, like fancier than that, but a spreadsheet where people can share that type of information. If it's a really sensitive project, it may just say, this is about reproductive health care. Call me at this number to get more information. But we're wondering what the legal considerations are beyond sort of project security. If nonprofits need to consent to have a project proposal, like if they submit a grant application, is there a presumption of confidentiality that we need to consider? Or are there other sort of things that percolate up, like bubble up for you, that you're like, you should think about these liabilities or these legal considerations?
Yeah, I would say generally I don't have much legal concern about what you're describing.
Okay.
I really don't. That being said, and I'm not giving you legal advice here because you're not my client, and I don't have enough facts to even give you legal advice, but just generally speaking, and a lot of times devil's in the details. There could be things that I'm not aware of that could give me some legal pause. But first off, yeah, I would generally say that while we're probably not talking about sensitive confidential information, if someone makes a grant proposal to one of your members and they're only making it to the member, I don't think there's going to be a presumption that member is going to share it with others.
Mm-hmm.
Again, I don't know it's much of a legal issue. Maybe it's more like a member relations issue, or just, because some of these might be very sensitive, right? On sensitive topics. We all know these days there's some topics that are extremely sensitive, and they might not want that out there because it might risk, angering certain folks who see that they're engaging in activities that others don't like. Think of, DEI related activities or gender affirming care activities or supporting immigration rights or abortion rights or, other things that are sensitive topics. And so I would say that before anything gets shared, that your member should have something in its, whether it's part of the submission process or just getting in the practice of sending an email back to a grant requester saying, please confirm that you're okay with us sharing this with other potential grantors, which generally they're probably all going to say yes. I mean, of course, right? Instead of just one, they get potentially dozens of others looking at it and potentially funding it. So I think the vast majority would say yes. But even then, even if they didn't, I'm not overly concerned because there's no like for something like that, there's not going to be a presumption of confidentiality or anything like that. And that's kind of the general rule that unless you're telling something it's going to be confidential or, the law says it's confidential, like certain health information or banking information or other things, it's generally not going to be deemed to be confidential, which would mean you'd be free to use it. But it's probably just a good practice. Beyond that, like, again, even if we make the presumption that your members are competitors in certain ways, and therefore that your organization is subject to the antitrust laws, the only things that would come into play, it's not an issue of price fixing. We're not dealing with that. It would be more market allocation is one of the antitrust violations that associations have to deal with, which is basically two or more competitors agree to kind of divide up the market amongst themselves. We're only going to work in this region, or we're only going to do this type of work. You're only going to do that type of work. We agree not to compete against each other. I don't really see that being an issue here. Of course, in any thing like this, there's always a possibility that a discussion could go down a bad path, and people say, well, we're going to only fund these types of grant requests, and we're only going to fund these types, and we're going to divide the market up amongst ourselves. That would be illegal if the antitrust laws apply, but it's not really conceivable to me that that's a likely outcome. It's just sharing of it, and yeah, I'm happy to fund this one. I'm happy to fund that one.
Right.
And if there's multiple funders that want to fund a particular request, they'll work it out amongst themselves, or the requester will decide what they want to do, or they want to accept. And beyond that, like I said, there's always in any situation the case that people could act in a bad way that creates liability risks, like tortious interference, like I'm going to prevent you from getting this funded or something like that, which would be a tort, where you're interfering with someone's business opportunity or contractual opportunity. But again, I see that highly unlikely for something like that to happen. So bottom line, I really don't have much legal concern about that. It sounds like a great idea. Yeah, and if Michelle, if you want to ask your other question, even if I answered it on
Yeah,
prior
the
webinar,
other
I'm
question,
sure it would be helpful to others.
the other one is broadly, I think, applicable, and I know you've addressed it before, but we're growing. We're statewide. We were regional, like in a city before, and so as we are growing, we have considerations, even more considerations around diversity of identities of the individuals on our board, but also the institutions they represent. So we have for always had conversations like, oh, we need more men on this board, or we need more corporate funder representation, and our nominating committee has had those unofficial conversations for years. We have applied two tools. One is before anyone is selected, there's an optional interest form. It was a way of sort of opening up interest in governance to serve on the board. So anyone can share their interest. You don't have to know me to do that. And on that interest form, we ask optionally for people to share information about themselves as an individual. So race and age and gender and LGBTQ status, whatever they'd like to share. There's also an open space to share identities that matter to you, skill sets. So if you're an attorney and you would bring that skill set to the board, if you have background in finance, and then also institutional information. What type of funder are they? Where are they located geographically? That type of thing. We then asked, and the committee uses that information. And I'm worried about what guidelines or guideposts we need to put in place about using that information and personal identity information in particular in shaping who is invited to be nominated and then voted on by the full membership to be a board member. And then after people are elected, we have had a survey previously that asked the same set of information that people can optionally share that helps us, make sure we're using their talents to the best ability, but also helps us officially track what the identities are on our board. And I'm just, with the shift in environment, we want to continue to build a representative board that helps also diversify the sector overall. It's important in Missouri, it's even more important. And we want to make sure we're not setting ourselves, our members, especially our nominating committee, up for concern.
Yeah, it's a very good question. First off, you're not located in California.
Correct.
If you were, you heard me say a few minutes ago the fact that California's employment laws apply to nonprofit volunteers.
Right.
And I would have serious concerns from a reverse discrimination perspective that those, even though they might not be strict eligibility criteria, that if you were in California, one could make the argument, or an aggressive, right-leaning plaintiff's lawyer, or a regulator, an employment law, HR agency regulator in a red state. Obviously, that's not California, but if that were the case,
it is Missouri, though.
They could make an argument that you are, discriminating against straight white men, for instance, because, by the way you're asking these questions and making your nominating committee selections, you're giving less opportunity for the straight white man, or even the straight white woman, or whatever the case might be. And that would be a serious concern these days if you were in California, where the employment laws apply to volunteers. In your state, as far as I know, that's not the case. And so while some people still misunderstand the fact, they think things like board selection are going to be governed by, employment laws like Title VII of the Civil Rights Act, but they're just simply not. They're not. In fact, we had a client, there was a board chair who filed an EEOC charge claiming that he was discriminated against by the executive director. because of his race and religion. And the case was dismissed by the EEOC because they said, sorry, but the employment laws just don't apply here. Even if you were discriminated against, there's nothing we can do about it because the employment laws just don't apply. So from a purely legal perspective, outside of California, I really don't have any concerns about that. But if you've heard any of the dozens and dozens of webinars that I've given on DEI issues, and there's a ton on our firm's website. We have a place on the website where we have webinar recordings, and I'll send those links to Tracy as well. And you can scroll through and see those. And one of the things that I talk about there, one of the things that we raise in every of the several dozen kind of DEI audits that we've done for nonprofit clients is the non-legal risk. The reputational risk, the targeting risk, the risk of boycotts, things like that. And granted, everyone's non-legal risk, the business risk, the financial, the reputational, the member relations, public relations risk is going to be different for every organization. But we all know that these are very hot button issues. Mm-hmm. And, if you have, particularly in your state, which is, I think most folks understand the politics, in a state like yours. It's not inconceivable that you could have some folks that see those criteria and say, hey, what the hell is this all about? What are they doing? They're discriminating against the straight white man, and this is wrong, and we should boycott them, or we should cut their funding, or whatever else might, and the funding cuts are a real threat for so many organizations, whether it's federal funds, federal grants, state funds. And so you definitely want to be cognizant about that. I'm not saying that you need to get rid of that. I'm certainly not saying at all that you should abandon your goal of having a more diverse board. And I think most nonprofits aspire to that. But you might want to consider what some of our clients have done that used to have those sorts of exact same practices. They've kind of abandoned that sort of more formalistic, asking people to self-identify their various protected characteristics and things like that, and just instead have the nominating committee just use their best efforts to try to get as much diversity in every sense of that word. I'm talking about people from certain types of jobs. Age diversity is a big thing. A lot of nonprofits, they need to get younger board members on there. And certainly racial, ethnic, sexual orientation, those sorts of, that sort of diversity is important as well, but to perhaps do it in a less easily identifiable way.
I think that was our practice before, and our intent on being more transparent about it. It was on purpose, right? Like we've added this in. It used to be, I would look at you, Jeff, and say, well, I think Jeff would be a male adding to our board, rather than ask you to tell me how you identify.
Right. No, I hear you. And it's a balancing act, right? That's what we said in every DEI audit memo that we've written. We said you have to balance your core values and what matters most to you against your risk tolerance,
right?
Both legal and non-legal risk, and make your own determinations. Certainly I understand the importance of finding out where people's strengths and weaknesses are so you can help identify what committees they should serve on or what task forces.
I think skill sets and geography and type of funder.
Yeah, that stuff's fair game.
I don't know. It's gender, it's race.
Yeah. The after the fact survey that you do, it's hard for me to even come up with a good reason why you're asking for all those identifying traits. Like I would
report out on identities at the board. I mean, that's like to be able to have a DEI related metric on our success.
But that's again something that a lot of organizations, not all, but some have moved away from, to have less things that people can point to as a target. And I'm sure you've seen that and heard that across the sector. Yeah, I'm not endorsing it. I'm not saying it's right or wrong.
And I know you've addressed this over the years.
And I'm not saying it's, and I always distinguish between the legal risk and the non-legal risk, because if you have legal risk, and some of our clients do, like for instance, there are tons of our clients that either had or sometimes still have scholarship or grant or fellowship programs where eligibility is limited based on race or other protected characteristics. Those are, in my judgment, illegal these days. The courts so far that have addressed this seem pretty clear that Section 1981 of the original Civil Rights Act of 1866 says it's illegal to discriminate in contracting on the basis of race. These things are generally all subject to a contract, although there is a lawsuit going on right now that I think it's the Hispanic Scholarship Fund,
Yeah.
something along those lines. They brought a lawsuit backed by some other larger nonprofit organizations, basically challenging the fact that these are not contracts subject to Section 1981. We'll have to see where that goes. Just personally, I wouldn't bet on the success of that case based on where we've seen the court so far. But we'll have to see how that all plays out. But so my point is, if you have that sort of legal risk, you got to change your eligibility criteria to something else, or some have just abandoned their program. So most have changed it to something else. But when you have to deal with this non-legal risk, you got to make more judgment calls based on all those considerations.
Appreciate that. Thank you. And I know Tony had a question.
Yes, and Tony's question, let me find it in the chat. Here we go. Where can we get good information, easy to understand for our members, on the changes impacting giving tax incentives for HR 1, i.e. One Big Beautiful Bill? And I should mention that the forum will host a post-FOF program on this and touch upon this as well during FOF. But Jeff, we would certainly be interested in hearing any guidance or suggestions that you have.
Yeah, I know what you're referring to, or what Tony's referring to, and it's been a little bit since that bill was passed. So I don't have that information top of mind. But honestly, the most simple ChatGPT search asking to explain those provisions will show you exactly what they are. And I don't know, from my recollection, they weren't hugely significant in the big scheme of things, at least compared to some of the proposals that were out there. But it's certainly important to understand them. And I just don't have, I can't cite them off the top of my head, but it should be a very easy search to figure that out.
Thank you for that. Deborah, do you have a question?
Well, it's funny. I've had like a couple pop into my head off of every topic we've had. And so I'm trying to figure out which one I want to ask. Because I could have really gone deep into the governance, that piece too, because I think many, we've all been really encouraged in the last 6, 7, 8 years in our DEI racial equity journeys to be intentional about diversifying our boards. So anyways, I won't go down that rabbit hole right now. One of the other questions I had when you were talking about the antitrust piece that came up for me, and I don't know if I don't have a valid sort of like, I know this is happening, but there have been some questions and inklings amongst nonprofits about their funders and whether or not there was, so there's a narrative right now about our sector that there are too many of the infrastructure organizations. And there's a sense from some leaders of infrastructure organizations worrying that some funders might have the power to sort of, I don't want to use the word collude, but agree who they're going to fund and who they're not going to fund and who's going to exist and who's not going to exist. And when you were talking about the antitrust, I was like, that sounds legal. But I don't know if that's.
I mean, it's possible. And unfortunately, there's not a lot of, at least as far as I know, there's not a lot of precedent on this question of, for instance, let's just say, loop them in a category of private foundations that are primarily grant-making foundations, right? I think that's when we say funders, that's a big group of what you're talking about. It's not all of them, of course, and there's some that are public charities and whatnot, but that's a particular brand or breed of funders that we're all aware of, and those are some of the biggest. The question would be, are they competitors amongst each other, right? Are they competing? Maybe they're certainly not competing for donor dollars because they're private foundations because they have one primary, typically funding source, like a family or a corporation or whatnot, but they're living off their endowment. And so they're not competing for donor dollars in the same way that, perhaps like members of some of your organizations are. But are they competing for grantees? I don't know the answer to that. It's probably, you know, what lawyers would call a case of first impression, because it just, I don't know that there's ever been an antitrust case, or at least with a reported decision and something like that. But if they're not competitors, then the antitrust laws don't apply. And then, you know, they can collude, and even if that collusion might translate into market allocation or a group boycott, or things like that, or even like price fixing, like agreeing on the amounts of grants or something, like all of that is fair game as long as they're not competitors. If they are competitors, all of those things are potentially problematic. Now, let's just make a presumption, you know, because I think it's probably a bit of a stretch to make the legal argument that they're competitors, you know, against each other for grantees. But let's say, you know, let's make that presumption that they were competitors. Then it would be illegal for them to, like, say, okay, I'm going to, you know, we're going to agree to fund these types of groups, but not these groups, or we're going to agree to fund this group, but not this group. You know, that's going to be either a group boycott and or a market allocation, both of which are illegal under the antitrust laws. And so, you know, again, it depends on whether or not they would deem to be competitors. But just like I, you know, told the electrical contractors last week that it's always fine for each individual company to decide what they're going to sell their services for, who they're going to do business with. Like, that's always fine. And it's fine for an individual private foundation to say, we're going to fund this group and not this, or this type of group and not this type of group. And people may not like it. They might disagree with it. They might have ethical or other concerns about it, but it's not going to be a legal violation under the antitrust laws.
That makes sense.
Anyway.
Thank you.
Sure.
Well, we are at time, but Jeff, thank you. This has been such a robust and nuanced discussion. Really appreciate your bringing your expertise and wisdom to this space and to our members. Laura, Michelle, Tony, Deborah, thank you all for joining us today. We're a small but mighty group. And fortunately for us, Jeff will be back later this year for another Ask a Nonprofit Lawyer. So be on the lookout for that announcement. But many thanks to everyone, and take good care.
Those are great questions, by the way. Thank you, everyone.
Thank you.
And I'll follow up and send those things to Tracy to send out to everyone.
Absolutely.
Take care. Have a good rest of your day.
Take care.
Thank you.